Dear colleagues and friends, thank you all for joining us today. My name is Juratowitch and I am the Senior Legal Officer at Mundi. It is my great pleasure to welcome you all on behalf of Mundi to this masterclass on arbitrators' appointment mechanisms, a topic of everlasting significance for arbitration practitioners. We at Mundi are delighted to have with us such a stellar panel of arbitration practitioners for today's discussion, which is dedicated to the protocol for agreeing on a presiding arbitrator put forward by Ben Juratowitch QC. Ben honored us by publishing his innovative protocol on our platform earlier this year. He was the first contributor in what has now become Mundi's new publication segment, hosting case comments and articles from senior practitioners from all over the world every week. Being conscious about the time, I would just like to mention that this webinar is being recorded so that you can watch it again at a later time or share it with someone who might be interested. The webinar will last 1 hour. We will have a discussion of 45 minutes with a Q&A of 15 minutes in the end. There is a Q&A box at the bottom of the screen where you may submit your questions to our panel. I will soon give the floor to our distinguished guest and moderator, Lucy Reed, who will then introduce the panelists. Although Lucy needs no introduction, a few words are in order. Lucy Reed is an independent arbitrator with Arbitration Chambers in New York, currently serving as president of the LCIA Court and president of ICA. She retired from Freehills in 2016, where she led the International Arbitration Group and then was professor and director of the Center for International Law at the National University of Singapore. While with the US State Department, Lucy was the US agent to the Iran-US Claims Tribunal. She's a former president of the American Society of International Law, chair of the Institute for Transnational Arbitration, and a vice president of the ICC Court. Lucy, thank you for being with us. The floor is yours.
Thank you. Thank you. I want to start by expressing my thanks to Mundi for organizing this webinar and thank in advance the panelists for agreeing to share your collective perspectives and wisdom on arbitrator appointment. And to all of you participants, I know you're out there, although we cannot see you. There's quite a good turnout, which shows how much interest there is in this topic. Well, Mundi already broke the rules by giving me a longish introduction. I am going to give short introductions to our panelists in order to save time. As an umbrella comment, I will say you are among truly masters on arbitrator appointments. So Ben Juratowitch, QC, is a barrister at Essex Court Chambers, formerly my partner at Freehills. He serves as counsel before international courts and tribunals in commercial arbitrations, investment treaty arbitrations, and disputes between states, and before domestic courts involving arbitration and international law. Dr. Dirk Pulkowski is senior legal counsel at the Permanent Court of Arbitration with broad experience as registrar and tribunal secretary in the most complicated investor state and contract-based arbitrations. In his life before PCA, hard to imagine that, Dirk did practice in international arbitration. As particularly relevant today, Dirk supports the PCA Secretary General in handling appointment of and challenges to arbitrators. Paula Hodges QC is head of Herbert Freehills global arbitration practice and serves as counsel in international arbitrations, again, the most complicated, particularly in the energy, telecoms, and technology sectors. She also sits as arbitrator. And as again, particularly relevant today, Paula is now president of the LCIA and plays a key role in arbitrator appointment. Now, our main focus today is on Ben's protocol, which is for a special or a particular list procedure for appointing the presiding arbitrator, which involves both the parties and the administering institution. We'll first hear from Ben about the protocol, we hope with some provisions shown on the screen, and then from Dirk and Paula from their particular perspectives under their different hats on appointment processes and their observations on the protocol as well. I will offer a few points from my arbitrator perspective, and then I'll throw out questions for discussion amongst the panelists. Most important, I will be watching the Q&A box here to take questions from the participants and pose them to the panel, either during the panel discussion or in the 15 minutes or so at the end. So let's get started. Ben, can I turn it over to you to explain to the participants why you wrote up this protocol and how it works?
Thank you very much, Lucy, and thanks to you, Mundi. Thanks to Paula and Dirk for their interest, and to everyone online today. I start from the proposition that parties have a strong interest in having an arbitration presided over by someone who they think will do a good job. And there's no need for any kind of protocol to achieve that if parties can readily agree on a presiding arbitrator. And it's not necessary either to have any kind of protocol if parties are happy to leave it entirely to the institution or entirely to the co-arbitrators to appoint the presiding arbitrator. However, experience suggests that there is a very large percentage of cases that do not fit into these limited categories. Parties want a say in the presiding arbitrator, that's quite common, but it's equally quite common for them not to be able to reach agreement on who that presiding arbitrator should be on their own. But nor often do they wish to leave it entirely to an institution or entirely to the co-arbitrators. Anyone involved in appointing a presiding arbitrator in cases of that kind has seen the appointment of a presiding arbitrator lead to some combination and degree of delay, frustration, and chaos. And each time the problem arises, there can be a sentiment, particularly among counsel, of trying to reinvent the wheel each time to try to find a solution. And so confronted with that, I started keeping records of agreements that had been reached in various cases between various parties with various different opposing counsel over time as to how to try to cut this Gordian knot. And that often involved a list procedure of some kind or another. And by list procedure, I just mean where there's a list of names and the parties rank them. But often those lists have historically been entirely composed by nominations made by the institution or by the co-arbitrators. And the cases where it seemed to work best were ones where the parties and the institution all put names on a joint list, with the parties choosing from among those names. And so I started to refine what I thought worked best and to propose it in a number of cases. And the goal was to provide a structure and time periods in which a fair and certain process could unfold. And that led to further refinement with the help of opposing counsel, institutions, co-arbitrators, members of my own counsel teams. And eventually, a number of opposing counsel told me that I should publish what had become a protocol. And I took some time to be convinced of that, because each time I proposed it, it was refined, more detail was added, it was changed slightly, it was scrutinized more by more people, and there was further practical experience with it, including what its weaknesses were. And so I was worried that by publishing it and therefore freezing it in time at the arbitrary point in time of publication, that process of improvement would stop. And so I was quite reticent to publish it, but pushed further. Mundi then solved that problem, because it can be and has been for a few months now published, but it can also continue to be improved over time with further experience and feedback. And so I'm very much looking forward to today's discussion. I've been asked to outline how it works, and basically it works like this. There is a list of 9 names. Each party nominates 3 of those names, and the arbitral institution nominates another 3. And there are variations on that, and there's a variation on the Mundi site where instead of the institution, it's the co-arbitrators, not wanting to burden them with too much work. It can be 2 for each party and 2 for the co-arbitrators, making a total of 6. Or one can even imagine a situation where the co-arbitrators and the institution each contribute as well as the parties, perhaps with 10, or it can be done in different ways. But in any event, let's take 9 as the base case, and then each party ranks 1 to 9, 1 being the first preference, 9 the last. Importantly, each party has 2 vetoes. So if you really don't want someone, and if you really don't want a second person, then you won't get that person. But what's not possible is to veto everyone that the other side proposes. Now, in this protocol, you don't know who the other side's proposed, as opposed to who the institution or the co-arbitrators have proposed. But mathematically, it's not possible to veto everyone that the other side proposes, or for that matter, everyone that the institution proposes, if it's 3 each and there's only 2 vetoes. The lowest combined score is appointed, and so that should lead to someone with which all parties are, if not happy, at least not wildly unhappy. Those are the general contours of it, and it sounds simple, and it is, but in order to make it work fairly and efficiently, it's necessary for there to be some detail, experience has shown. And so on those details, either side can nominate criteria for the institution to consider, but the institution is not bound by those criteria, especially if they're not common criteria shared by all parties. The parties in this protocol agree that the institution is not limited by any list or committee system. And for some institutions, that's quite important because it empowers them to nominate names that the individuals involved in administering the arbitration think would be best for that case, without being constrained by a list or a committee system. Another detail is it's the institution that contacts the candidates, not the parties. And so the candidates don't know who nominated them. And each party doesn't know whether any party that they did not nominate was nominated by the institution or by the other side. A further feature is that availability, conflicts, and declarations are all checked before the name goes on the list. Now that takes time, and it takes procedural dedication on the part of the institutions. But the result is that it means once anyone's on the list, it's clear that they're available, clear that they're free of conflict of interest, and any declaration that they might wish to provide, which falls short of a conflict of interest, comes along with their name on the list, so that when the parties are ranking candidates, they can take into account declarations to the extent that they wish to. Now, if there's a tie in the score, then it's the lowest difference between the different candidates that results in the winner. So if someone is ranked 2 and 5, giving a total of 7, and someone else is ranked 3 and 4, also giving a total of 7, then the person ranked 3 and 4 will be selected by agreement of the parties, because the gap between those 2 rankings is smaller. And so the level of contentedness of the parties with that person should theoretically be closer in magnitude. If it's still a tie, then the institution chooses, for example, if it's 3-4 by one and 4-3 by the other party, then it's the institution that chooses on the basis of favouring diversity. But that's not the real contribution, if there is one, of this protocol to diversity. More generally, the real importance of the diversity is each party and the institution needs to propose 3 candidates. And it is very hard for anyone now to propose 3 white, straight, able-bodied senior men from a developed country. And it's certainly impossible for the institutions properly to do so. And so it should lead to a more diverse list, and thereafter it's down to party choice as to which name is ultimately selected. Perhaps the last general characteristic to bear in mind mind is that at the same time as I hope encouraging diversity in this structural way, it should at the same time encourage quality, because the baseline incentive for any party is to propose people that you would be happy with, that the other side is likely to regard as good, at least once the psychological disincentive, possibly, of knowing that the other side proposed them is removed. And the reason that this protocol is quite fastidious on keeping confidential who proposed any given candidate, obviously you know who you proposed, but in keeping confidential who proposed anyone else, is to remove that potential psychological disincentive, which any of us who have been in the role of suggesting presidents for arbitral tribunals has heard, which is people saying, well, if the other side wanted them, then I don't. It removes that psychological disincentive. And by doing so, if a party proposes someone who is objectively a good candidate for this case, then the other side has no reason not to rank them reasonably well on the list. So those are my general comments. I'm obviously happy to take questions and comments in due course, but in the meantime, Lucy, back to you.
Thank you, Ben. That was very clear. Dirk, what are your perspectives from your perch in the Peace Palace?
Thanks very much. It's a pleasure to be with you and join you on this discussion. I thought to start with, I might give a bit of context as to how things are usually done because at the PCA, because I think you will see that many of the ideas that have made it into the protocol are things that have recently been tried out in UNCIT trial and PCA arbitrations. So if you look at the bigger picture, there are really these three groups of actors who can be involved in the appointment process: parties, co-arbitrators, and the appointing authority. And the default assumption in arbitration is, of course, that parties should have an active role to play. And this is not only a nod to the principle of party autonomy, but I guess from our perspective, more fundamentally, looking at the process from the vantage point of a procedure theory of justice. Party involvement is also intended to contribute to the acceptability of the future decision and foster a perception among the parties that justice is being done. At the same time, I think Ben has described the potential risks of party involvement. We don't want to compromise impartiality or, in fact, cause the selection of an arbitrator who is selected on grounds other than capability. So how have we dealt with that process? Well, when asked to appoint a presiding arbitrator, the PCA ordinarily follows a list procedure as envisaged in the UNCIT trial rules and the PCA rules. And I think many of those elements are common to the protocol that we're debating today, namely consultation of the parties with regard to the arbitrator profile and preparation in that context of a list by the appointing authority only, but with all candidates having confirmed availability and absence of conflicts of interest before the list is put to the parties, strikes and ranking of the candidates by the parties, and then the selection by the appointing authority, quite similarly to here on the basis of the rankings. But what's perhaps more interesting is that various alternative mechanisms have been agreed in recent PCA arbitrations. So we've seen alternative procedures for making nominations to the list by the parties, by the co-arbitrators, by the Secretary General, or a combination of these three actors. We have seen parties agree to limit the number of strikes, or in fact even exclude strikes entirely and put their faith entirely in the arithmetic logic of ranking. Conversely, we've seen parties, instead of ranking, limit themselves to providing comments on the qualifications and suitability of candidates. So in that case, the appointing authority would be empowered to make a qualitative assessment of the candidates in light of the comments received. The appointing authority has also been asked to share the responsibility for the selection of a chairperson with the co-arbitrators. Sometimes that has been done in a fairly simple way by simply asking the appointing authority to appoint in consultation with the co-arbitrators, whatever that then would mean. And it can actually work if everyone is reasonable and plays along. And finally, the appointing authority can be asked to select the chairperson from a short list jointly elaborated by the parties without disclosing, of course, at that point, which candidate is originally the preferred one by one or the other party. So as you can see, there are many cogs and wheels in the appointment process that can be adjusted. And I think Ben's protocol quite carefully selects some key parameters and calibrates them cleverly, and takes on board many ideas that we've seen tried out in recent arbitral practice. And I think that the goal is quite clearly to maximize the parties' substantive involvement in the process while avoiding any direct links or even perceived links that may remain with a party. So there are two questions, and I think I will probably leave most of the answers to the discussion. But the first question I asked myself from an institutional perspective, is the protocol actually practicable from our point of view? And the second would be, is it worth it? Perhaps just a few comments on the first question before we move on. I'd say from our point of view, yes, the protocol is practicable, at least when an institution acts as that clearinghouse, that appointing authority. I have some doubts as to the co-arbitrator's ability to conduct that process as efficiently. There is a degree of complexity there due to the degree of Chinese walls and barrages and confidentiality measures that have been put in place that can be managed, I think, through step-by-step instructions from the institution. It would be a fairly heavy burden on the co-arbitrators. And similarly, the task of approaching candidates to check interest, availability, and freedom from conflicts of interest is a fairly heavy one, which I think institutions have the resources to do so, but I'm not sure every set of co-arbitrators would be so well placed to conduct that process.
Thank you, Dirk. Paula, how about your perspectives from both your LCIA appointing related role and as counsel?
Thanks, Lucy. Hello, everyone. And I'm delighted to be with you today. So if I start with the LCIA appointment process, I checked before the webinar today as to what the stats were for 2021, because the LCIA has recently published its latest casework report. And I was slightly surprised actually to find that of all the LCIA appointments, the LCIA court was involved in 42% of appointments, parties still at 44%, and then co-obs at 14%. So that's just to say that the LCIA is very much involved in appointments, particularly if it's a sole arbitrator or presiding arbitrator. And I think that's what we're really looking at today in terms of Ben's very interesting protocol. In terms of why the LCIA is so involved in appointments, you'll probably know that the default is that the LCIA makes the appointments in all cases, actually, and that's to make sure that there's quality control and people are available. But needless to say, the LCIA does take into account the parties' wishes in terms of the selection process. And although I'm not aware of Ben's protocol being used in a case as yet, certainly we'd be open to thinking about it. The process that's gone through now is as follows. The Secretariat at the LCIA will look at the case, look at the subject matter, and any points that and criteria that the parties have articulated, and then we'll put together a short list for review either by me as president or one of the 5 vice presidents, and then we will make a choice. In putting those candidates forward, we don't have a closed list. There's complete freedom for both the Secretariat to put candidates forward, and then for the president and the VP to come up with additional candidates and try and find someone that's suitable for the appointment. Now, in that process, it's rare that the parties will ask us to follow a list process. And so it is very much down to the LCIA and the president VPs to come up with a list of candidates from which we will then make the decision. So I find Ben's protocol very interesting, because if that were proposed to the LCIA, then we would have more idea of the candidates that the parties wanted us to take into account. Because by the time it gets to the LCIA, if the original intention was that the parties would make the choice that haven't been able to reach an agreement, the parties more often than not tell the LCIA who they have not agreed, and then we will make sure that we do not choose one of those candidates so that we avoid any sign of bias to one side rather than the other. And so this protocol actually would get over that hump in a way, in that the parties could still offer a choice. I suppose my only questions are the time that it would take for the LCIA to check 9 candidates, get to a situation where you had 9 conflict-free candidates. If the LCIA is involved in the appointment process, we obviously check out whether candidates are available, whether there are conflicts, whether they're going to make a disclosure. And we very rarely then go forward with a candidate that makes the disclosure, so that we don't get into delays. So we try to have sort of conflict disclosure-free candidates. So one question is the time it takes, and I'm quite drawn to the 6 arbitrator number. Just switching to my counsel hat briefly before I hand back to Lucy. I always think it's better if the parties have some involvement in selection of the sole or presiding arbitrator. So to that end, the protocol is very appealing. One question mark I have is the extent to which it really will push the dial on diversity, because certainly, again, wearing my LCIA hat, it's the institutions that are really making progress in selecting diverse candidates, whether that's in terms of gender, first-time appointees, different jurisdictions and nationalities. The parties are really still lagging behind. And the other question mark is, the involvement of the co-arbitrators, because I think it often provides for a smoother process if all 3 arbitrators can work together effectively. But look, I'll leave it there for now, Lucy, and hand over to you.
Thank you, Paula. I just have a few observations. The first is I am a big supporter of the protocol. Well, here in the discussion, it's not appropriate for every kind of case, for sure, but in general, I'm a big supporter. First, from my perspective from many years as counsel, I appreciate how often each side, and if it's not the lawyer, it's the client, feels compelled to reject any name proposed by the other side for the presiding arbitrator. That's Ben's phrase, psychological disincentive. It's a tedious process. It's a wasteful process leading to the loss of many good candidates. Second, from my perspective as co-arbitrator, I may surprise you by offering the counterintuitive and probably minority view that I do not like the role of selecting the presiding arbitrator with my co-arbitrator. I am very relieved when I don't have to do it. Why is that? It's time consuming for sure. If my co-arbitrator is a close colleague, or not so close to be a conflict, but a close-ish colleague, we're going to risk ending up selecting the same old, someone we both know and want to sit with. If the co-arbitrator is not known to me, it can be touchy with the discussions about, oh, I don't know that person, or I do know that person. For me, there's something to be said for having a chair who has been selected by others, even by a total stranger, as a protection for really total independence and freedom in discussion. You can be free to disagree without any reservations. This is a similar point to what is often said about how pleasant it is for a tribunal to know that all 3 of you have been appointed by an institution, no party role at all. So between the appointing authority, even good ones like the LCIA and PCA, sending a name down from on high to be the presiding arbitrator, and the protocol, which involves the parties as well as the institution. I very much like that idea in the right cases. Now, we have one technical question from the participants that I want to pose up front, Ben, and that's this question: what if all party recommended candidates say no? I know the answer to that is in the protocol. So why don't you explain how that would work?
If I've understood the question well, it's what if someone nominated for the list declines to go on it? Is that the question?
Correct. And the question comes across as all three, but it's the same answer. Whenever one party nominated candidate says, no, thank you, I can't do it.
So the short answer to that is that whoever proposed that candidate then gets another choice. And that's done as between the institution or whoever's administering the process and the candidate. And so when that result eventuates, and it's not uncommon, simply whoever had the right to appoint in the first place gets another go. And same for the institution. If the institution has 3 candidates to appoint and one of them isn't available, or issues a declaration that the institution considers inappropriate, and I hear very much what Paula and Dirk say about institutions being very conservative about declarations, then they can simply withdraw that candidate and appoint someone else. And that's all done before the list is finalized.
Okay. A second technical protocol question is, how much can a candidate get involved in the process when she or he is recommended by one party? And as I understand it, the answer is not at all, except when that candidate is contacted by the institution to check conflicts, capacity, and interest. There's not a role for a person who knows he or she has been nominated by a party to lobby for himself or herself.
No one couldn't, because they wouldn't know who to lobby, because the appointment process is all through the institution. And I entirely agree with Dirk that that part of the process is best administered by an institution, even if it's the co-arbitrators who are providing the 3 or 2 names or however many it is. The actual administering of the process of contacting the candidates and going backwards and forwards, the institutions are by far the best equipped to do that. And with all the respect I have for many arbitrators, that's just not their sweet spot. And the institutions are much better at it.
I guess, Ben, I mean, the way I would use the protocol if I were using it would be, if I were a party, I would send my names without reaching out to my 3 candidates in advance to see if they're interested, available, and not conflicted. But I guess it wouldn't violate the process for counsel for one party to do that, provided it's repeated by the institution. That would be, I think, the underlying assumption for this question about, once arbitrator candidate A knows he's going on the list or she's going on the list, what should they do?
My own view is that it's best, and this is the default procedure proposed in the protocol, which anyone's free to change. This is not legislative. This is just a protocol that parties can adapt. But the way it's proposed is that no candidate would ever know who proposed them. And the only interaction they would have would be with the institution if it's administering the process. They would provide some information, which is their CV. That sounds pro forma, but it's not unimportant, in the sense that one of the defects I've found sometimes is that different parties have different degrees of knowledge about a particular candidate's experience and other cases they've sat in. And that matters more in some types of cases than others. And sometimes people have very, very limited information available publicly, including as to cases they've been in. And so the provision of that CV to the institution, which is then provided in turn to both parties, is an important aspect of decreasing information asymmetry in the process. But apart from providing confirmation as to availability and absence of conflicts, any declarations and a CV the involvement in principle should be none.
So that's one thing to learn from this webinar. It takes discipline on the part of counsel for the parties. Ben, I'll start with you. What is your actual experience with using the protocol or variations of the protocol? How often have you used it? How long did it actually take? Do you have any sense whether at the end of the day, the names from the institutions are selected more often than the party names? So this is a compound question. I'm not doing cross-examination, sorry. And confidentiality, how does that work in your experience?
Yeah, I'll try to take the different parts of that. On timing, and Paula raised this point too, and I think it's a good point. I haven't seen it take more than a month. A month sounds like a long time, and it is a long time, but I've seen it take a lot longer if there's not some process agreed. I've certainly seen this take much less than a month. It principally depends on how many people are available, what the declarations look like, how much back and forth there is between the institution and potential candidates before the definitive list is constituted. Once the list is constituted, it's easy. It's the constitution of the list that is difficult. And I agree there might be cases where having a lower number, and 6 is the obvious number because then it's 2, 2, and 2, could really potentially speed things up. That's timing. How many times have I used it? I haven't counted exactly, but in various formulations, it would be a dozen or so, perhaps more. Some opposing counsel like the idea of a structure. Some opposing counsel don't want to let go of the degree of control that they feel they have absent this kind of structure. So it's definitely not something capable of agreement in every case. But I think a lot of people feel that there's a sense, and I mentioned the expression of reinventing the wheel. This is a problem that exists in many, many arbitrations, which no one particularly enjoys dealing with. And there is a way to do it that involves some sort of precedent that can be adopted for a case. So that covered timing, how many times I've used it. What else did you want me to ask, to answer?
Fair enough. As counsel in a case using the protocol, you would know if your name was selected.
Yeah.
And do you have any sense in your experience as how often a party name is appointed as compared to an your party name as compared to an institution's name?
So I have no idea how many times it was the other party or the institution, because you don't know as between those categories. The only time you know is when it's someone you put on the list. And that's happened a number of times. And it's happened for candidates that it's not where we were trying to be tricky or appoint someone who we thought had a particular predilection for our kind of point in our kind of case. It's just a good, sensible person that we'd be happy to have as presiding arbitrator. And on a number of occasions, counsel teams of which I've been a part have put people like that on the list and they've been chosen. So it's not that it's always the institution's candidates. It is, at least in my experience, if a sensible person is proposed, that person has good prospects of being chosen.
Now, I know you well enough to know that if you knew your name had been selected, you would keep that confidential. But have you had experiences where the other side boasts a bit about its name having been selected for the presiding arbitrator?
I've never seen that. I can see that it would be conceivable. I don't think it will get anyone very far, because if the presiding arbitrator knows that this is the process, then I think the presiding arbitrator is not going to be very influenced or impressed by that kind of boasting. And so the only boasting that could happen would really be vis-a-vis their own client, in which case, okay, well, they put someone on the list that was good enough for the other party to agree on, and maybe they'd be boasting about it in that direction. So I think it's entirely possible. I just don't see that it would really have much impact.
Dirk, with the PCA list procedures, how, say you need to get 9 names to put on a Ben Juratowitch protocol list, how many candidates in your experience would you likely have to reach out to get a clean list of of 9?
Yeah, that's a good question, because I think one may underestimate the work that goes into this. A list of 9, if one were really thinking of calling up or emailing 9 arbitrators, and that's the end of the story. That may well be the case in smaller and less complex commercial disputes where, in all likelihood, looking at the names of the parties, no repeat appointments or no conflicts of interests are likely to arise. But in our investor state arbitrations, honestly, if we were to put together a list of 9, we would probably be checking somewhere between 14 and 18 candidates in order to, in the end, be able to return a list of 9. And a list of 9, of course, as Ben and you have noted earlier, meaning a list of 9 with no disclosures or very minimal transparency, for the sake of transparency, only disclosures. And that's really where things get complicated. First of all, we actually do get a number of arbitrators nowadays replying simply to say that they would be honored, but at this point have decided not to take on any arbitral appointments as they have a full docket and want to remain available and on the ball and just don't have the time for that. And that is increasingly it's a good thing, I think, but it's increasingly something that one has to reckon with in compiling the list.
Thank you. Paula, any comments on this line of questions before we move on?
I'll just say this, Lucy, as I said, as far as I'm aware, the LCIA hasn't used the protocol, but we'd be open to doing that. And I noticed one of the questions that's been raised is, what do we think would be appropriate cases? And I think this would be particularly appropriate in ad hoc cases where maybe there isn't even a appointing or administrating authority involved, and this would bring one of the institutions in play. Obviously, the parties would need to agree which one, but would then smooth out the process, because I have to agree that the institutions are a bit more of a well-oiled machine when it comes to checking arbitrators' availability.
Quick question, Ben, from Mundi themselves. In an arbitral award, it's normally recited who appointed or how the presiding arbitrator was appointed. If the protocol is used, would the award recite that the protocol method in identifying the presiding arbitrator?
I've never thought about that. I mean, it's a species of agreement between the parties. So it's effectively the parties agreeing on the appointment of the presiding arbitrator using a particular structure. I suppose it would be up to the arbitrators to decide what they wanted to contain in their award. I think the protocol is entirely silent on that question, and I don't think it really matters in the end.
Here's a big multi-part, not multi-question, but multi-part question that incorporates several questions from the participants. Ben, you said, and we repeated it, that the protocol is not necessary or even suitable for all cases. So what are the parameters of cases where it would be useful, including multi-party cases, always complicated, and treaty arbitrations as compared to commercial arbitrations? So observations from all on that suitability question.
Well, if I may start, I think it's the least suited where you have good, reasonable counsel on each side and a dispute that doesn't turn on what someone else is likely to have decided in some other case that's publicly available. Because then everyone behaving reasonably should be able to work out someone that people are happy with. It sometimes doesn't happen even in those circumstances. And then it's necessary to revert to some kind of procedure. It might be this or it might be something else. But I think it's probably too complicated and detailed for that kind of case. As for investment treaty arbitration versus commercial, it's more likely, I think, to be well adapted to investment treaty arbitration because the problem that I just identified exists much more often in investment treaty arbitration. But it's equally possible to use it in commercial arbitrations, and I've used it in a number, when it's just a question of, well, we're just not going to agree here. Often it's because of clients, not because of counsel. And so what counsel can agree on and encourage their clients to agree on is a structure which doesn't favour one party or the other. And then you don't need to agree on a name, you just have to agree on a process. And on Dirk's point about procedural justice, which I think is really important, you agree a mechanism that ensures procedural justice, and then the process is just followed. As for multi-party, in the introduction to the written protocol, I specifically say it doesn't deal with multi-party, at least if there's not two sides. Sometimes with multi-party cases, it's pretty obvious that there are two different sides. And so either they can cooperate on appointing as though they were one party or not. But it doesn't solve that problem. You could tweak the protocol to seek to solve that problem by having multiple parties ranking and multiple parties contributing. That would be entirely possible. I haven't done that in practice, but theoretically it could be done. It would stop the institutions having the final say, which is what often happens in that circumstance. And with all the respect that I have for institutions, I personally am very happy when institutions make appointments. But lots of parties and lots of counsel don't want decisions made by institutions. That's just a practical fact. And so this protocol seeks to allow institutions to be involved and administer the process without them ultimately having the final say.
I'm willing to bet, though, Ben, that there have been circumstances in your career where you have been unhappy with the person appointed by the institution.
Yes.
I certainly have, although you can't do anything about it. Dirk, for you, how about focus on treaty arbitrations? And does this fit in with the UNCITRAL rules or ICSID rules? Well, I guess you wouldn't worry too much about ICSID, but how would it work?
Yes, I mean, I primarily focus on UNCITRAL and PCA rules, though I don't think actually on this point, the situation under the ICSID regime would be very different, because the appointing mechanism under the ICSID convention is also one of those aspects which is subject to other agreement by the parties. The UNCITRAL rules are fairly clear in that regard, insofar as the parties, or the rules apply only to subject to such modifications as the parties may agree. So the starting point is certainly that the parties are free to agree on a different appointment mechanism other than that set out in the UNCITRAL rules. And perhaps there's another opening. If an appointing authority comes into play, then the UNCITRAL rules prescribe a default list procedure, but don't actually mandate the use of that list procedure in every case. In fact, the appointing authority can determine that a different process is more appropriate in view of the circumstances of the case, as it says on the rules. Now, there is potentially a complication in treaty-based investor-state disputes, and sometimes parties have tended to argue along these lines. Is it open to the investor as a disputing party, but not a party to the original treaty mandating the UNCITRAL rules, to give that consent to modify the appointment mechanisms? Or did the states parties somehow contemplate that the UNCITRAL appointment mechanism would apply unmodified? It's a question that could be raised in the appointment process, and since this may be a question that PCA Secretary General will have to address in that case, I won't take a view on it. But it is a potential risk or complication that could arise, though not necessarily an unsurmountable one. I think otherwise I would probably agree with Ben as to the universe of cases for which this kind of process is appropriate, because it's a bit of a heavy process, so it will probably not be attractive for very small cases or cases where counsel, in any case, domestic arbitrations, for example, operate in the same ecosystem and perhaps actually can agree quite efficiently on a short list themselves and have simply an appointing authority pick one of those 5 agreed candidates. But if it's a more sensitive case, there's a lot to be said for that process, and suddenly the 30 days that Ben has mentioned doesn't look very long at all, given, as we see sometimes in the record of these arbitrations, the parties spend months agreeing and discussing and trying to agree on different mechanisms for appointing a presiding arbitrator. Sometimes the co-arbitrators also give it a try and are not successful. So, and I think that also then goes to the question of whether we need the level of detail and complexity. Well, probably actually, if the parties are really attached to that principle of being allowed to propose names, actual names, into the process, as opposed to simply abstract criteria, then the answer is yes, you need that level of detail, because otherwise the process can easily be derailed due to a disclosure glitch that may appear and suddenly make it very obvious where a particular name has come from, and you need to start from scratch, or in fact, one of the parties may lose trust in the process. So I would think for these kinds of cases, it's actually a well-designed and pretty ingenious way of proceeding.
Thanks, Dirk. Paula, this is morphed into a two-part question for you. The first is, from your perspective and experience at LCIA, what kinds of cases that you see do you think this protocol would work well for? And do you think is it too complicated? Are there simplifications that you might propose?
From an LCIA perspective, and we're mostly dealing with commercial cases, that can involve a state or state entity, of course, but not treaty cases. Very often does happen, but not so often. So I think, and of course, the LCIA also administers ad hoc arbitration. So as I said earlier, I think it'd be very good for ad hoc. I also think it's good for multi-party cases, because especially with 9 candidates, it does give each side or each group of claimants or respondents 3 candidates to come up with and feel as if they're all having some impact on the process. In terms of making it more efficient, I would think of 2 things. When you haven't got multi-party claimants and respondents, I wonder if you could reduce it to 6 candidates. And also, I think that there's a particular stage in the protocol around step 9, where the institution receives the list of candidates from both parties, and there's at least one common name, if not more. And I wonder if at that point, the institution can step in and say, right, well, I'm going to choose one of those, because both sides have put it forward, and whether or not that is written into the protocol or is just done on the initiative of the institution is, of course, open for discussion. So those are the points I'd mention at this stage, Lucy. I'm conscious you've probably got quite a few other questions coming through the Q&A, but if I've dealt with your question, you can move on.
Thank you, Paula. Your last point leads to one of the questions that's just come in, and that's diversity. So if 2 sides each put 5 names forward and they each pick as their first choice the same candidate, there would be certainly a time benefit to the institution for picking that person. But does that necessarily help diversity in real life? And the question specifically in the Q&A box is there room? And the answer is yes. Is there room in the protocol to put in a requirement for diversity in the 2 or 3 names put forward by each party and by the institution? I'll turn that over to Ben first, but it's important for the participants to understand the parties agreed to the protocol and can adjust the protocol. So that diversity requirement would have to come from the parties, I assume, Ben, or perhaps be suggested by the institution in administering the protocol. What are your views on that?
I agree with you on both points. And there's room in the protocol for anything parties wish to agree. It's not, as I said before, it's not legislative. This is just a precedent that parties can adopt as they wish or not in any particular case. And so if all parties are committed to diversity and they want to record that in the protocol, then by all means. And the idea of the institution suggesting it, I think, is interesting, because institutions have made observations on this protocol over time. They've asked questions, made suggestions, and that's led to some refinements. And I'm very conscious that institutions are in the best position to watch diversity issues as well as to contribute to their resolution. And so I think that kind of initiative would be welcomed by many parties, perhaps not by some, but certainly by many. If it's the kind of case where there are counsel and parties on both sides that are likely to agree that diversity be included, it's probably unnecessary because those parties are going to suggest a list of 3 or whatever the agreed number is that in some way represents diversity. But in principle, the answer is yes.
Any comments on that from your experience, Dirk and Paula?
Well, I kind of had a similar thought actually as our commentator in the chat box. I had marked up as a potential paragraph 5A of the protocol when it comes to composing the list, possibility to specify diversity criteria. And what these criteria are may differ from case to case. Gender diversity is the obvious issue at the PCA, though we also see a lot of discussion about appointing arbitrators from different parts of the world, including by parties, states in particular, from different parts of the world. So I wouldn't see a problem in adding that. I think it is correct that institutions do actively try to promote diversity, though sometimes we struggle to see what the ideal definition or the most appropriate definition of diversity in a particular case is, as there are many factors that come into play in addition to gender diversity, which obviously must be part of the picture. We certainly strive to, if we run a list procedure, provide a list that is diverse and varied. And if we were asked to operate under this protocol, we would certainly take account of that in proposing the 3 names.
Thank you. You just answered someone's question about whether the institution can be required to consider diversity by the parties. I think the answer is yes. Paula.
Yes, I wasn't sure if the question was, can the institution insist on diversity? Where I don't think that is the case. It would have to be written into the rules of the parties that already agreed it. So of course, it would be great to write into the protocol and have all the parties agree that they're going to at least be guided by diversity impetus. But my guess is, bluntly, it will be down to the institution to really focus on that in terms of the 3 candidates that the institution puts forward.
I would observe, I have no doubt that using the protocol or using a different form of a list procedure is helpful for diversity, if only following the pledge and thinking carefully about what names you propose. We're coming to an end now. We just have like 2 minutes. A number of the questions in the Q&A reflect, like, for example, what happens if you get your list of 9 as counsel and you see conflicts for everyone. That won't happen if the protocol is used correctly, because the institution will have vetted conflicts and thereby minimize challenge. But the questions suggest, the questions answer the first question that came into the Q&A box, which is, how can participants benefit from this webinar? And the answer to that is, participants who haven't read the protocol can benefit by looking at the protocol. It's not painfully, to use Ben's word, it's not painfully complicated, several pages, and there are examples. It's available for free on Mundi. You can download it, you can amend it for use in your cases, consider for discussing with your client. And by looking at the protocol and the footnotes that explain some of the variations, that's the benefit of this webinar, to opening the availability of the protocol. In our last minute or so, any final observations? First from Ben, then Paula, then Dirk.
Just on conflicts of interest, which a number of people have asked about, it doesn't solve that problem. If an arbitrator candidate says that they have a conflict of interest and their name doesn't go on, if the institution judges that they do, they don't go on as an institution nominated arbitrator. But the conflict will get the parties to an agreement on the basis of declared availability in absence of conflicts and declarations, but it doesn't solve every problem. But thank you, Lucy, Dirk, Paula, and Mundi, and everyone involved for their interest and discussion today. Thank you very much.
And Lucy, I would add to the remarks you made earlier, not only will the participants in the webinar benefit from this, but certainly I have benefited hugely from discussing the protocol with you all, wearing my LCIA hat, counsel hat, arbitrator hat. I think it's a really interesting proposition. And so we'll look forward to using it in the future. So thank you, Ben.
Thanks. And just to make a brief, broader point, what I like about the approach taken in the protocol is that it highlights that different actors in the process bring different perspectives and insights to the table. So it's not just a matter of can institutions find the better arbitrators, or can counsel find the better arbitrators, or co-arbitrate. Each of them have different experience and bring a slightly different perspective into the process. So if we find a way of bringing those perspectives together, I think that really results in a more optimal appointment process. The parties know things about the case that none of the other actors know. So it certainly makes sense to give them a more specific say. The co-arbitrators may have a sense of how it feels like working with certain people, which can be very helpful. On the other hand, we found that the co-arbitrators sometimes have outdated ideas as to how busy arbitrators are, or perhaps how sharp they are at their stage of the career, where in fact institutions see arbitrators in action all the time. So I think bringing those perspectives together is a very helpful thing and will result in better appointments.
Thank you all. Over to Georgios from Mundi with a question in the chat room is, could you please recirculate the protocol to participants now that we've piqued their interest? Thank you.
Sure. Thank you, Lucy. Thank you to our panelists for this fascinating discussion, and to Lucy for moderating it. And thank you very much to the hundreds of attendees for their numerous questions. I wish you all a great day, morning, afternoon, or evening, depending on where you are. Have a good day. Bye.